So good morning, good afternoon, or good evening to all of you. First of all, I really hope that everyone is healthy and fine in these very hectic days. Myself, I'm back in Belgium, as you all know. We work a lot from inside the house, but so far everything goes quite well. Now, during my stay in Brisbane, which unfortunately came to an end after only 2 weeks, I was supposed to speak on the regulation of artificial intelligence in the European Union, and would thereby especially focus on autonomous vehicles. Well, I will still do this presentation, but at the end of this presentation, you will find my contact details. So if things are unclear, or you would like to have more information on something, or you want to discuss an issue, please feel free to contact me again. And I very much look forward actually hearing you and getting some feedback on this presentation. Now, as you may know, AI is a hype. We have Elon Musk that says that AI is far more dangerous than nukes. Stephen Hawking even said that AI may mean the end of human race. So both of these persons actually illustrate the dangers and the risks of artificial intelligence. It is therefore no real surprise that lawmakers, policymakers in different countries, in different jurisdictions, have tried to regulate the consequences of artificial intelligence. Now, in this presentation today, I will mainly focus on the regulation, as I said already, on the regulation of artificial intelligence in the European Union. Now, I will start by defining AI and by robots. I will thereby depart from European framework. So how do we define, how do we qualify robots and AI in the European Union? I will then look at the legal framework, the existing framework on artificial intelligence in the European Union. I will then assess and examine this framework with autonomous vehicles as a case study, because I think autonomous vehicles are by far still the most important application of AI, considering that a lot of research has been done on autonomous vehicles so far. I will show that a multi-stakeholder approach is necessary in the sense that people with a different academic background, being it lawyers as well, academics, practitioners, will need to work together to properly tackle the many challenges that are created by artificial intelligence. I will finally conclude with the main findings of this presentation. Now, if you look at the concept of artificial intelligence, it's not really challenging, it's not really straightforward of defining artificial intelligence. There's a real AI hype, is what I said. A lot of research is been conducting on AI so far. A lot of things are currently being written about it. So it seems that basically everyone deals with an aspect of autonomous decision making. Now, defining AI may be an easy question to ask, but a very hard one to answer. And that's because we actually have two elements. We have the concept of artificial and intelligence. So far, there's no understanding, no common understanding of what is known of what we understand under intelligence. It's also a very complex question because legal scholars and lawyers are often no computer scientists. So when we deal with this machine learning, with deep learning, with neural networks, for legal scholars and lawyers and people that are not educated with a proper scientific background, it's sometimes difficult to grasp these concepts. And we also have a major influence of movies and stories on the perceptions of AI. For example, if you think of Isaac Asimov's Robot's Law or I, Robot the movie, this has an influence on how we perceive and how we see, how we would qualify robots and artificial intelligence. Now, in the European Union, a lot of documents exist already, and I will come to it in a later stage. But we have the major documents are the communication on artificial intelligence for Europe of 2018, and we have the reports of the high-level expert group on AI, the so-called HLEC AI, the AI HLEC group. Now, both of these documents depart from what I call a rationalistic approach, in the sense that they define artificial intelligence as systems that display intelligent behavior by analyzing their environment and taking actions with some degree of autonomy to achieve a specific goal. So it means actually that you give machines, certain machines, the ability to achieve a specific goal in an autonomous way. If you look at autonomous vehicles, for example, they are programmed to drive, and they will achieve this goal, namely driving, preventing accidents in a way by using autonomy and in an autonomous way. Now, so you have this rationalistic approach, which departs from the assumption that a machine has the ability to achieve a specific goal in an autonomous way. So without human intervention, without humans programming it somehow during the course of the action. Now, in the white paper of artificial intelligence, which has been published in February 2020, so it's very recent actually, it's been stressed that the definition of AI needs to be sufficiently flexible, but also being precise. And the white paper refers to the high-level expert group activities on AI for its rationalistic approach, and stresses that the main elements that compose AI are data and algorithms. So again, the algorithms are trained to infer certain patterns based on a set of data to determine actions needed to achieve a given goal. So again, you see this rationalistic approach where a machine is able to achieve a specific goal in an autonomous way. This is the key of artificial intelligence, how we see it in the European Union. Now, if you look at robots, normally it's qualified as a type of automation of a process by a machine, or machines that are capable of doing physical tasks. We think about factories, for example, where you have these robot arms. But in this presentation and more in these documents that are relevant for robots in the context of AI, it relates actually to a physical entity or system that uses artificial intelligence. And if we look at the EU Parliament civil law rules on robotics, it stresses that that robots have the ability to make decisions without any human interference. So this means that they can make decisions, again, without that humans are involved and independently of external control or influence. I listed some examples here. We've got, for example, robot Sophia, which has been given citizenship by Saudi Arabia, and it can actually travel around the world because it has citizenship. We also have the Hoover robot, and we have a care robot where they actually perform these tasks autonomously in an independent way. So we've defined artificial intelligence, we've looked at the concept of robots, and the next point, of course, is yes, AI has many benefits. AI systems might be more accurate and efficient than humans. For example, if you look at the use of robots in surgery, well, they are more precise than humans. This is why they're increasingly being used. AI systems and robots also increase productivity. Because, yeah, of course, they do not need holidays, they do not need a break, they do not need to go outside for a smoke, so they can basically constantly work, and this will increases productivity. They can also perform many tasks better than humans. For example, self-driving vehicles are safer drivers than humans. Maybe the picture on the right side of the slide is a bit confusing, but studies and empirical studies and experiments have showed that that self-driving vehicles are safer and better driver than humans. AI systems also have access to more data, to loads of data sets, so they can actually make better decisions. Of course, it will then determine what do we understand better and how is it qualified. But the idea is that because they have access to way more data, they might make more clever and better decisions. And I already said it, there are also some sector-specific advantages. For example, self-driving vehicles in transportation sector, well, they increase safety. And also with fully autonomous vehicles, even though it might be a dream still before they can be relied upon, before self-driving vehicles, fully autonomous vehicles can be used. Well, in this case, if they would ever become fully autonomous, well, this would have also an efficiency, a time efficiency factor, because you as a user of the vehicle, the ones who are inside of the vehicle, may do other things instead of driving. So you see basically that there's a lot of benefits of AI systems. With benefits, of course, there also come many challenges for AI. It has already been said that they are better than humans in certain tasks, so they could eventually take over humans' work. Professor Harari refers to the useless class of people that they might no longer be involved in work. Think about the taxi drivers, for example. At the moment there are fully autonomous vehicles, well, taxi drivers might become a bit redundant, let's say. There's also a tested experiment, of course, it was in a specific setting where AI systems competed against human lawyers to detect errors in non-disclosure agreements. And of course, no surprise, the AI systems were way faster and way more accurate than human counterparts. We also see another challenge, of course, is that there's so-called biases. This means because humans program it, and because the data might not be of sufficient quality, or there might not be sufficient data, well, biases can exist. And I used the Google image example there, where Google images were trained on based on an algorithm. They were able to detect certain elements, for example, a sky scrapper, or an airplane, or some cars, some bikes. But then it went wrong when it concerned two black friends, where the system actually qualified it as gorillas. So this is a huge biases, and we should, of course, prevent this. You also see, you might also refer to another example. For example, Amazon uses a algorithm to in the selection procedures for job applications, and it turned out that there was a biases because women were discriminated. So depending on the programming, depending on the data that you use, you might create biases. And another challenge, of course, is that these AI systems, vehicles, or other AI systems will cause damage. We have this picture there on the right of the slide, which actually shows that a self-driving vehicle will cause damage, and the question then will become who should and who can and who should be held liable when such an AI system causes damage. I will discuss this in a later stage, but it is also a challenge, and it's not straightforward to determine who should bear liability. Now, when we talk about AI governance on a general level, three things should be taken into account. First of all, we should assess what may be done. This is the law. The law describes what you may do. You also have this ethical. We all talk about AI governance and the ethics of AI, ethical guidelines of AI, and this relates to what should be done. What do we want AI systems to do or not to do? And we should ensure that humans remain in the loop. We should ensure that humans always have this kind of oversight. So this deals with the question, what should be done? What should we do? What should we allow AI systems to do and not to do? And finally, a third aspect when it comes to AI governance relates to what can be done. This is the technological developments. What are the abilities of these systems? So when we talk about AI governance, we'll do it now, but the moment you read something on AI governance, it really relates to these three elements. And of course, it depends on and there's an interaction, of course, between all these different categories. Now, the regulatory framework, as you might not be really surprising, is that considering the importance of artificial intelligence, there are many initiatives. It seems that lately, whatever organization, country, think tank, policy, government, academic institution, they start writing these brochures, these reports on artificial intelligence and the regulation of artificial intelligence. Now, when you take a proper look into all these reports, there are similar topics and issues that are often addressed. For example, it starts by how do we qualify AI? What is it? It again then stresses the risks and the benefits of AI. The ethical considerations should be taken into account. The need for a proper legal framework. The need to be investment in AI, and center of excellences should be created. And the countries, for example, that issue these guidelines, for example, stress that they should take a leading role when it comes to the regulation of artificial intelligence. Now, considering all these different initiatives, but at the same time, the fact that similar topics and issues are covered, I think the focus on the legal situation in the European Union might be more interesting. Also because EU is, with its trustworthy AI, the concept of trustworthy AI, is really leading the debate on ensuring that AI is ethical. This is why we will focus on the situation in the European Union. Now, when we look at the European Union, I think this slide is really important because it captures my point of view and it captures the essence of the presentation. And I will briefly discuss all of these four elements in the remaining time. First of all, there is no such thing as AI law. I said there's no such thing as AI law yet. It might come, but it's not there yet. And I don't think that it should be a good way. I don't think it's necessary to have an AI legislation as a separate body of rules in the future. So this is the first claim. There is no such thing as AI law yet in the EU, and I don't think it's necessary in any way. This, of course, does not mean that AI is unregulated. We have a lot of legislation in the EU. for example, the Product Liability Directive or the GDPR, that applies already to AI. But this is this is not AI law as such, but existing legislation already applies to AI systems. There are, of course, if you look at the third element, there might be some limits to what can be solved with existing law. Of course, there can be problems. So there can be confusion about the applicability of existing rules and how to interpret them in the light of artificial intelligence. So despite the fact that the existing legislation applies to artificial intelligence, well, there might be some problems with the existing framework. When you have to adapt it, when you might have to modify it, my claim is to do it by a step-by-step incremental approach. Don't do something rash, don't do something radical, don't change the law radically, but take it step by step to examine what might be possible. Because with a minor change, you could already achieve the result that the benefits of AI are used while the risks of AI are reduced. And finally, I also first claim, I said that multi-stakeholder approach is necessary to tackle the many AI challenges. So these four aspects, there is no AI law. This does not imply that AI is unregulated. Limits to what can be solved with existing law and some solutions might be necessary. And the multi-stakeholder approach, these four elements are really the core of my remaining presentation. Now let us first start with the fact that there's no AI law. There is no AI law in the proper word of in the proper meaning of the word. Of course, the European Union has issued many documents related to the regulation of AI. In 2018, for example, the European approach to artificial intelligence and robotics was issued. Three pillars were of importance. The EU wanted to be ahead of technological developments, thereby encouraging the uptake by the public and the private sector. This was the first pillar. The second pillar was to prepare the European Union for socioeconomic changes created by AI. And the third element was to ensure an appropriate ethical and legal framework. So these are the three pillars that the European Commission used in its approach to AI. Subsequently, there was a coordinated plan on AI, which actually urged countries, member states, to cooperate together to ensure the proper development of AI. And a very important group that was established under this European approach was the high-level expert group on artificial intelligence, the AI HLEC, as we say it in the EU. So the idea was that their task was to support the implementation of the European strategy on AI. So the European Commission had this approach on artificial intelligence, and it then tasked a high-level expert group consisting of 52 experts from different fields related to AI. So we had legal scholars, we had scientists, we had people skilled in programming robots, we had people with an ethical background. So a whole list of experts were appointed to support the implementation of the strategy on AI. The most important document that this group AI HLEC group issues were the ethic guidelines on artificial intelligence, and with the concept of trustworthy AI, which I will discuss later. They also issued the policy and investment recommendation. So there is no AI law, but there are several documents which illustrate and point towards the importance of artificial intelligence. So with this EU strategy, I already said that the HLEC group was established and it issued the ethics guidelines on artificial intelligence in 2019. What was the idea? The idea was to promote trustworthy AI. What is trustworthy AI? Well, it's AI that is lawful and that complies with the law, that is ethical, so that takes ethical considerations into account, and that is robust, that is safe. Now, this was the departing point of these guidelines to promote trustworthy AI. Now, when the idea was then that the development and use of AI systems have to meet 7 key requirements. This means that if you are an AI system developer or a deployer, or when you use it or when you create it, 7 key elements should be taken into account. They relate to human agency and oversight, which means that actually humans should always remain in the loop. Humans should have this oversight. They should remain of primary importance. An AI system should also be technically robust and safe. It should not be able to hack it, for example, so safety should be ensured. It also relates that an AI system complies with the GDPR, guarantees privacy of users, and there's also some mechanism with regard to data governance. AI should also be transparent, should take into account diversity, and of course non-discrimination and biases should be avoided. It should also be environmental and societal well-being should be taken into account, and AI systems should be accountable. So now these 7 key requirements were put forth as the elements that AI developers have to comply with. So an AI system needs to comply with these 7 requirements. Now, this was the assessment list that is being issued. This is how it looked like actually. So you have an AI developer has to take into account this assessment list. For example, did you carry out a fundamental right impact assessment? Blah 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 blah. Does the AI system interact with decisions by human? Blah blah blah. So per category of the requirements, you have a whole list of questions that someone who developed AI should be taken into account. Of course, when you look at the list, you see that you could actually really say on every question, yes, 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 and show that you have completed the list without actually proving which guarantees, which safeguards, which measures you took to ensure that your AI system complies with these ethical requirements. As you see, the pilot version has been given a lot of feedback. So the feedback is handed into the European Commission in December 2019, and we're now in this phase where everything is being evaluated, and we will see what will be the outcome of the evaluation procedure. So these are the ethical guidelines, but of course the main question that is asked by legal scholars in the EU is whether these ethical principles and these 7 requirements can already be addressed and are already covered in existing legislation. Because of course this is important. If it's already existing in the law, well, these requirements might be a bit useless because they already exist. Another thing is, if they exist in the law, then AI systems already comply with it. And this is what my research team is now currently doing. We look at the translation of these ethical guidelines into the legal framework. And we see, for example, that privacy and security elements are sufficiently covered by data protection law, and more specifically the GDPR. We see, for example, that the ethical requirement of reliability and safety, you can translate it in product liability provisions, in tort law provisions, in medical devices regulation. You see the requirement of transparency and accountability, again, is translated already and can be found in data protection law, product liability directive, and so on and so on. So what you actually see is that these ethical principles are to a certain extent already translated and already found into the applicable legal framework in the European Union. Another thing that becomes important, and this is a huge academic debate now, and the huge priority actually in the European Union, is the need for certification of trustworthy AI. Right? So of course, when you are an AI developer, when you develop AI systems, for example, when you write algorithms or so, then you will want to show that your system complies with these ethical requirements. Because if it complies with ethical requirements, then it might have a competitive advantage. Now, this certification could be very important because you get a label saying, yeah, this AI system complies with the 7 requirements. This is very nice in theory, but how do you do this in practice? Who should certify this? How will you do it? So these are the typical questions that me and my research team were now working on, and we're trying to find, in addition to these ethical principles into the legal framework, we are also trying to provide translation of these ethical guidelines into metrics, so that a certification body can properly show with a certificate compliance with these concrete certification requirements. So I think this is a major academic and I think a lot of research will be going on this requirement of certification of trustworthy artificial intelligence. Now, I already said in 2018 we have the departing strategy on AI. We have the HVAC activities, but of course, more important, in February 2020, we have the European Commission white paper on AI. Commission President von der Leyen said that when she would be in office, after 100 days, she would have legislation on AI. Eventually, legislation became not possible, and this is my claim. There is no AI law, and I don't think it should be possible, but a European Commission white paper on AI was issued. Now, this white paper contains 2 important elements. First of all, the first pillar relates to the creation of an ecosystem of excellence. What does it mean? it means that that we should invest in developing skills related to AI. There should be sufficient investment in AI research, and an uptake by AI by the public sector should be encouraged as well. So this was the first pillar of the white paper, and creating an ecosystem of excellence. So this means that actually the EU should be leading when it comes to AI, when it comes to the trustworthy AI, and it should really trigger public and the private sector to invest in artificial intelligence. More importantly is that in addition to this first pillar, we have the second pillar, which aims at creating an ecosystem of trust. There's a need for a solid regulatory framework for trustworthy artificial intelligence in the European Union. So the pillar really aims at creating this legal framework that is sufficiently able to deal with the many consequences, undesirable consequences of artificial intelligence. So this first step requires to examine the legal framework and assess whether, as it exists now, might be sufficient to deal with the consequences of artificial intelligence. Such an analysis of the applicable framework will also identify where modifications might be necessary. This is what we're currently doing with my research team. We're looking at some legislation to see whether it's adapted to the reality of artificial intelligence, for example, GDPR protection, for example, the Product Liability Directive, and if it's not adapted, where some suggestions, where some solutions are possible. The Commission nevertheless says that new legislation might be necessary for high-risk AI applications. So the qualification of high risk becomes really important, and I reckon that in the coming months there will be a lot of feedback on this. How do we define high risk? Where is the distinction between high risk, for which additional legislation might be applicable, and low risk, for which the existing framework might already be sufficient? Now, in this white paper, the European Commission actually uses two elements: a sector and the use. So to define whether an AI system is of high risk, you can look at the sector. For example, mobility is a high risk sector. Health sector creates high risk. So this is one element. The second one is the use. Depending on the use of a specific AI system, it may create some high risk and actually affect fundamental rights, for example. And also in certain exceptional circumstances, the European Commission, regardless of this qualification, regardless of these two criteria, qualifies a specific item as high risk. For example, recruitment in the employment sector can be high risk, and therefore it should be it falls under additional legislation. Now, what is the content of this additional legislation for high-risk AI application? Well, there are specific requirements for training data, there are record-keeping requirements, the human oversight should really be ensured when it comes to high-risk applications. So a lot of additional requirements. So the consequence, of course, is that many AI developers will want to say, yeah, my AI system is not high risk, it's low risk. So this distinction between high risk and low risk will become important in the future. And again, the stress for certification will become important, and is, again, I already mentioned it, a very important issue that will for sure be addressed more thoroughly in the coming months. Now, so I've showed that there is no AI law. This was my first point. There is no AI law, despite the fact that legislation is favored for high-risk applications. It's still not existing, and I really don't know whether it will eventually come and how it will look like. It will for sure be what I would say general, soft law, more maybe risk-based approach, so no really hardcore legislation, I believe. This was my first point. My second point, and it's captured on this slide, is that some laws already apply to artificial intelligence. It's not because there is no AI law yet, or there is no AI law, that AI is not regulated. No, there is GDPR, the data protection for personal data, which applies for AI systems, and which we're currently with my research team also examining. How is this relation between artificial intelligence and the GDPR? We have AI and product safety. We have the consumer protection rules in the European Union that apply to AI systems. So there's a whole bunch of legislation, of applicable legislation that already applies to AI systems. Of course, within this applicable legislation, within this applicable legal framework, there are some challenges to what can be solved. And so there might be a need for solutions. So, for example, if you look at the GDPR, it applies to personal data. Of course, AI has the ability to link data that is non-personal, to link it with certain other elements, that it becomes personal again. This is problematic somehow. We have purpose limitation under the GDPR, which means that data can only be collected for a specific purpose. So it should be mentioned towards the users for which purpose the data is collected. Of course, AI has the ability to data that is collected for one specific purpose, that it can be used for another purpose. For example, data that is collected via social media can well be used by AI systems for example, insurance purposes. So this is unclear how this will be dealt with for artificial intelligence. There's also a whole debate whether there's a right of explanation under the GDPR, yes or no. But in any case, there might be a reason that with regard to automated decisions, a producer or a developer will have to show how the decision was taken for the user. So this is the black box principle, and this can also be challenging, because how will you explain to someone who uses an AI system how it comes to this decision? And we don't really know. We know the input, we know the output, but we don't really know how an AI system came to that decision. This is with the GDPR, a lot of interesting issues already arise. More importantly, the remaining parts of this presentation will focus on product liability and autonomous vehicles, and this will be used as a case study for my 2 points. Namely, there is some law that applies to AI, namely the Product Liability Directive, but it can be problematic and some solutions might be necessary. But again, some minor step-by-step solutions. We do not need radical solutions, and this is what I will show in the next remaining parts, because we've seen there is no AI law, there is no AI legislation in the EU, but, and it's mentioned on this slide, some laws already apply to AI, but there are challenges and limits to what can be solved with the existing framework. Now, as I said, I will show this with autonomous vehicles. Why autonomous vehicles? Because I think it's one of the most important applications of AI and robots, because a lot of research has been done on it and is currently being ongoing on autonomous vehicles. So it makes it a very interesting case study. I will first discuss some facts and some evolution. I will then briefly discuss the concept of autonomous vehicles, and then I will come to my key elements of this presentation, namely the liability issues. Now, self-driving vehicles, a lot of tests have been going on by Uber, Tesla, and Volvo, and also by other car companies. So they're testing autonomous vehicles. A lot of tests are also going on in EU member states. For example, in Belgium, in the city of Antwerp, a lot of tests are going on with autonomous vehicles. We also have several EU initiatives. For example, the Concordia project, a project which makes a road infrastructure, which actually investigates how road infrastructure should be adapted to the reality of autonomous vehicles. Because you first, of course, need a autonomous vehicles, but also the requirement that road infrastructure is adapted to these robots actually. Some say that autonomous vehicles might already be available, fully autonomous vehicles might already be available within 5 to 20 years. I think it's, and not me, but the several authors of the projects I work in, engineers, say that it might be a bit too optimistic, because on certain closed parcours and closed circuits, self-driving vehicles might work very well. For example, at airports where there's no risks and where the road is always the same, it can work quite well. But in city center with so many risks, it's really difficult to get them fully autonomous. So these are some facts, the background on autonomous vehicles. Now, when you look at the legal framework, well, at the European Union level, there's a high-level group, GEAR 2030 report. Do not confuse it with the HLAC group. This is another high-level group. We have a lot of them in the European Union. It issued a report, and one of the main findings was that it should be clarified what we can still expect from drivers or users of the autonomous vehicle. Shall we not change the driving license system to make sure that drivers, users of this vehicle, actually become aware how an AI system in such a vehicle works? And instead of the traditional driving license, there are voices that say that we should change it to really allow the people to bring in some knowledge on how these autonomous vehicles could work. It also said that the report also said that the Product Liability Directive, which I will discuss later, was sufficient for systems expected by 2020, but might be problematic afterwards. But my presentation will already show that the Product Liability Directive is already problematic for these systems already now. So we're 2020, but already now this product liability directive can be problematic. In addition to EU initiatives, we also have several national initiatives. For example, in Belgium, we have the very famous Article 59(1) of the Belgian Highway Code, which actually allows tests with fully autonomous vehicles without a driver. There should be someone in a control room, but a driver is no longer required. So in addition to the factual background, we have this legal framework where you see that a lot of things are going on. And the main question, the main issue is, what can we still expect from users? What can we still expect from drivers in those vehicles? And what is the product liability directive adapted to the reality of autonomous vehicles? As I said it already, autonomous vehicles, they have several benefits. They are efficient because eventually fully autonomous vehicles, in those vehicles, people might do other things. You can work already because you don't have to drive anymore. You don't have to pay attention to the road anymore. Such autonomous vehicles, even if they're not fully autonomous yet, will increase safety because they are safer and better driver than humans. And autonomous vehicles also have a social benefit because it allows people that are currently not able to enjoy traffic, for example, the younger, the minors, for example, people with a handicap, or for example, the elderly people who are currently not able or restricted to participate in traffic, would be allowed to participate in traffic with autonomous vehicles. But so these are some benefits, and I reckon that you see some overlap with the general benefits of AI that I already discussed. Now, before we start with the core business of the liability issues, is that we should know how autonomous vehicles work. We have 5 stages in the human operating process of a vehicle. This means that you might not be aware of it, but when you drive a vehicle, there are 5 stages. First of all, you have this localization. You realize where you are. When you're sitting in a vehicle, the first thing you do is where am I? Let's say. Then the second stage is perception. You see things around you. You see things happening around you. This is the second stage. The third stage relates to the interpretation of what you see. You will interpret, you will give meaning to what you see somehow. Based on this, you will make a decision. And finally, in the final stage, you will execute this decision. So these are the 5 stages that we all do when we operate a vehicle. Of course, we do not longer realize it, but these are the 5 aspects that when you start driving, you realize it's very hard. But of course, the more you drive, the more automatic it all goes. The essence of autonomous vehicles is that the user of the vehicle, or the driver, let's say the user or the driver, is assisted or replaced by technology during each of these stages. So in each of these human stages of the human operating process of vehicle, so in each of these 5 stages, well, gradually this is taken over by technology. And you can actually see it very well on this slide, where you have on the left side, you have the different stages in the operating process: localization, perception, interpretation, decision, and execution. And on the right side, you have it shows how technology replaces or takes over all these stages, human stages, in the operating process. For example, when it comes to localization, well, we have the GPS that will help tell us where we are. When it comes to perception, well, we have sensors on these vehicles that will actually that will give you a view of around the vehicle. And with regard to interpretation, decision, and execution, well, we have software. So in each of these stages, technology is gradually taking over or replacing the tasks of the human in this operating process. Of course, technology will not immediately take over all control of the user over the vehicle. No, it will do so in different steps. It will do so gradually. For example, first of all, technology provides information to the user. For example, your GPS tells you where you have to go. Then we have the stage of automatization, and I stress the matization because it relates to the implementation of the instructions of users. For example, if you brake or you speed, then you give an instruction, and this is implemented by the vehicle. And a third stage is autonomization, which means that the vehicle takes its own decision. For example, it stops automatically, or it parks, it goes to the left or to the right. So basically, this is the stage we're in now when I talk about autonomous vehicles. Well, this is the fact that the vehicle, the essence of an autonomous vehicle, is that it makes its own decision. And I refer to this discussion of the robot previously, at the fact that it makes its own decision without any interference of humans. Now, I already said that we have many benefits of autonomous vehicles, but there's also, of course, some challenges. I refer to the job losses. I refer to the fact that public infrastructure needs to be adapted. It will be costly to adapt public infrastructure to the reality of autonomous vehicles. There will be some ethical aspects as well, because the question will arise, what decision will the autonomous vehicle have to make when it has a choice between, for example, killing 4 people or killing 3 people, or for example, by killing 2 older men or women and instead of killing 1 baby. So these are the ethical dilemmas faced by autonomous vehicles, and I refer to the website of the Moral Machine, where you can actually do this test yourself. More important in this presentation is, of course, some legal challenges, and I already said it, the qualification, who is a driver, who is a driver, until when in this process of autonomization, when do you stop being a driver? This is very interesting to examine. What is the role as a driver? Can software be a driver? There's a very famous case now in the Netherlands, where it said that in not fully autonomous vehicles, but semi and level 3 autonomous vehicles, the driver is the human driver is still considered as driver. So the human user of the vehicle, the one behind the steering wheel, is the driver and not the software, because the plaintiff in this case said, yeah, well, the software system is actually the driver, but the court disagreed. And another element that is important from a legal perspective is, of course, liability for damage caused by autonomous vehicles. So we have this general setting of autonomous vehicles. It's a reality. A lot of research is going on autonomous vehicles. The law is gradually being adapted to it as well. We have many benefits, but we have many challenges as well. One of which is liability, and the essential question then is, who will be held liable when an autonomous vehicle causes an accident? Because as you see on the pictures, as you see on these journal flashes, let's say, self-driving vehicles will cause damage. And we have several examples. Not as many accidents as normal vehicles, regular vehicles, but they will cause some accidents, and even there's also even someone who died in a Tesla car accident. So the question as to who will be liable becomes essential. Now, of course, the question who will be liable triggers the following question: what are the different regimes? Well, in many jurisdictions, you have fault-based liability, which actually depart from the fault of the user driver of the vehicle. For these fault-based liability regimes, for example, in Belgium and France, we have Article 3082 of the Civil Code. Fault-based liability regimes in common law jurisdiction will relate to the tort of negligence, for example, where there's a breach of a duty of care. So this is based on a fault. Now, in the context of autonomous vehicles, you have to make a distinction between 3 categories. For example, in the first one, there's a control. There is no interaction. There is no interaction between the user and technology. So this is what it is. These days, you as a driver, you still have control over the vehicle. You still have control over the movement, over the motion of the vehicles. This is the first stage. The stage when there is fully autonomous vehicles is, of course, there is no interaction between computer and the user, because it is the user, it is the computer, the software used in the vehicle that takes all decisions. So from a fault-based liability perspective, this is not really challenging. So the first category, where there's no interaction, the user remains in charge, well, we have fault-based liability as it is nowadays. In the latter category, the final category of no control and supervision, when there is no interaction between the computer and the user driver of the vehicle, well, this will not be problematic from a fault-based liability as well, because the user does not influence the motion of the vehicle, so it cannot commit a fault, to put it simply. So these categories are not really problematic. But the most important and most problematic category, and also the most important one, because this is the one we're in these days, relates to supervision, in which there's an interaction between the human driver and the software system. The software system takes the initial decision. For example, the car decides to brake, to go to the left, to go to the right. But you, as a human driver, you can still overrule it. You can overrule when there's a wrong decision, or when your car gives you a signal like the bing, 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 bing. You might be required to overtake the control of the vehicle. So this second stage is problematic, because when do you commit a fault as a driver? When do you not commit a fault of a driver? What is the influence of force majeure, for example? When the vehicle does something unexpected, can it be qualified as force majeure? So I showed this on the scheme actually. Then in the first category of fault-based liability, when there's control, as it is nowadays, no problems with fault-based liability. And also in the third category, when the software system takes all decisions, no problem when it comes to the fault-based liability. But in the second category, the most important one, where there's supervision of the human on the initial decision taken by the software system, this can be quite problematic. And how can it be problematic? Well, if you look at fault-based liability, the first issue will be, when will there be a driver? I already said it, that when will, I already mentioned it, in this process of technological the autonomization process, when will the person behind the steering wheel, let's say, stop being the driver? Who is the driver? This is important and should be determined by national law. Another interesting issue is, can you attribute these acts of the autonomous vehicle to the driver? Because, for example, it is a vehicle that crosses a red light. You do not prevent you fail to prevent the vehicle from doing it, but you do not commit the initial act. You do not commit the initial wrongful act, which is, for example, crossing a red light. You just don't intervene to prevent it. So, but can you actually say that it's the same violation? And if you would say this is a fault of the driver, it might be far-reaching. And I already said to which the question is, to which extent an accident caused by an autonomous vehicle can be qualified as force majeure and thus not leading to the liability of the one inside of the vehicle. I wrote an article on it in English, so if you want I can forward it to you because it's quite technical. But the violation of a statutory rule of conduct, and the first aspect of fault-based liability is problematic. Another element is negligence. When you do not apply the required care from a normal, prudent person placed in this, similar circumstances, this will be actually also challenging when it comes to fault-based liability. Because how do we know? We do not know yet how such a system works. So it will be very difficult to determine whether we were required to intervene, whether we were required to overrule a decision or not. When is this considered to be negligent? This will be quite challenging. Moreover, the autonomy of a vehicle actually triggers risky behavior and triggers some negligent behavior, because you do not pay attention to the road anymore when a vehicle does it for you. So this autonomous vehicle might actually lead to more negligent behavior. And there's also some studies that have been shown that the switch from software, so when your software system tells you to take over the vehicle, it's unrealistic to expect from humans to do this within a fraction of a second. So my point is actually that fault-based liability will be challenging, and it will become very difficult to apply it. The more the vehicle becomes autonomous, the more difficult it will be to apply. Now, so you have to find other regimes. Fault-based liability becomes unlikely, so you have to take other regimes as a departing point. The question then is, who can and who should be held liable? Who can be liable will of course be determined by national law, and who should be held liable is another question. It's more a policy question, a policy issue that is currently being addressed at the EU. Now, the question who can and should be liable, of course, we have several alternatives in national law, and we have the custodian of defective objects, for example, in Belgium and France. But more importantly, and this is why I think it's more interesting, we also have an European Union directive concerning the liability for defective products. And you might already see that it becomes interesting to see whether to which extent this product liability directive applies to autonomous vehicles. And this is what I will discuss in the next slides. And I will actually show that despite the fact that there is some legislation, some problems can occur. And this is what I mentioned again in the previous slide somewhere. Now, under this product liability directive, says that the producer is liable for damage caused by a defect in the product. So, of course, we have different kind of producers. First of all, we have the producer of the autonomous vehicle. This will not really be a problem, because the producer of the autonomous vehicle or its material parts will be held liable. Now, of course, we would like to put, and this is my claim in my article as well, it would be maybe an idea to put like liability on the producer of the software, because he's considered as the cheapest cost avoider. It's a concept of the law on economics literature, which means that you should place liability upon the actor that can prevent the accident by incurring the less costs. And I think that this could be the software producer, because he has the information and expertise to increase the safety of the autonomous vehicles. He knows the risks, and I think that he can make sure he can take the information, can take the actions to ensure that the safety of the vehicle is increased. So my claim is now that we could maybe place the product liability directive on the producer of software. Now then it becomes challenging, because if you look at the product liability directive, it is problematic for software producers. For example, as I already said it, the producer is liable for damage caused by a defect in a product. The first question is, what do we qualify under the directive as a product? A product is defined as all movables, even though incorporated into another movable or into an immovable. Product includes electricity. So is software a product? Yes or no? There's a lot of debate on it, and it's still unclear. It's still unsure, because even in recent documents, the European Commission does not give any guidance. Some say no, it's not a product, it's a service. So this means that the product liability directive is not applicable, and no liability, no strict liability for the producer of software. Others say no, because it only relates to tangible goods. This is why electricity was included in the scope of application, and software is not considered a tangible goods. Others say, and the European Commission agrees this a long time, mentioned it and acknowledged this, that yes, the product liability directive applies to software because it's software captured on a tangible medium or device. But still, it does not give an indication as to the question whether software, non-embedded software, can be considered as a product. And others say, and this is what I believe as well, yes, software should be a product, because if we look at the directive when it was drafted in the 80s, of course, software, as it is now nowadays so important, was back then not that important. But if you look at the directive, it clearly had a very wide material scope, because it included electricity. So I think that if you take, use a teleological interpretation, you could say, yes, the product liability directive is very wide from scope, and this is why software should be included. So you see, my point is that software, is it a product, yes or no? You have this product liability directive framework, but it can be problematic for AI systems. A simple solution, and not something from a revolution, not something radical. It will eventually come that the national judge should file a preliminary ruling to the European Court of Justice asking, is software a product? Via this way, and when the judge could simply request the European Court of Justice via preliminary ruling saying, is software a product, yes or no? This will resolve the problem, as has been done with, for example, the right to be forgotten. A lot of academic debate. Eventually, it came, the question of the right to be forgotten came via a preliminary procedure in front of the Court of Justice, which decided that there should be such a right. Of course, it created a lot of other problems, but you see that with somehow a realistic, feasible solution, things can be resolved. So the producer liable for damage caused by a defect in the product. We have discussed the product and the relationship with software. Another thing, of course, is the defect. The producer will only be liable for damage when it's caused by a defect in the product. In the European Union, we use this. The consumer expectation test, which means that a product is defective when it does not provide the safety that a person is entitled to expect, taking all circumstances into account. So we talk about legitimate expectations. What can we expect? The product will be defective when a person does not expect the safety that is entitled to expect. So it is a broad and vague criterion, and it's also difficult to assess for new products because, for example, what can we expect of self-driving vehicles? What can we expect? Absolute safety, yes or no? So the legitimate expectations will be very important when it comes to determine whether an AI system is problematic. But it's interesting to see that this, with regard to self-driving vehicles, well, producers of autonomous vehicles should actually mention that their vehicles do not provide safety. Because if they stress, and it has been done so, if they stress the fact that their vehicle increases safety and is safer and better than traditional vehicles, well, this fact will increase the liability risk of producers because it provides safety that one is entitled to expect. So the more you emphasize the fact that the vehicle will provide safety, well, the higher the expectation, the higher the legitimate expectation of the public. Now, this means actually that the consumer expectation test, as we use it in the European Union, almost relates to absolute safety. So the producer of an autonomous vehicles is exposed to a very, very large liability risk, and this could have an impact on technological evolution. And because the risk is so high, these innovative these innovators might be restricted from creating safer stuff, from innovating into technological products, so to say. An option could be to adopt a risk utility test, which has been used in the United States, and which actually stresses that there's liability if the safety risk of a product is higher than accepted in comparison with social benefits. So you take more the perspective of the producer, and you look at whether there were safer alternatives, and the user and the producer did not use them, so to say. So you could actually, again, the solution which could be possible, which could be implemented in the European Union under this definition, because we give it the definition, the safety that a person is expected the safety that a person is expected to receive. We give it a consumer expectation test, but it might well be that we connect it to the position of the producer by adopting the risk utility test, which has been used in the United States. So again, a problem for AI, but some solution that can be solved here. Another element, I already said that the producer is liable for defect caused in its product. We discussed the product and the requirement of artificial intelligence. We discussed the position of the concept of defectness, and now there's also another ground in the product liability directive, which says that the producer of a product is not liable if the defect that caused the damage did not exist at the time when the product was put into circulation. And so there's no liability if the defect came into being afterwards. So the problem here, of course, with autonomous vehicles is that the moment they're placed on the market, they might be working perfectly. But because of software updates or because of self-learning possibilities of these systems, well, they can become defective at a later moment. But for these defects, the producer is not liable, and victims will not be able to claim recovery. So what the solution could be is the moment there's a software update of a vehicle, in such a vehicle, a software update could be considered as a new moment of placing the vehicle into the market. And by this moment, by finding this new moment, well, then claims can be initiated. More problematic is a requirement that with self-learning operating systems, it will become very difficult to determine when such a moment for the product was put into circulation. So it will become unclear to see when this product was put into circulation. A solution could be there to scrap this, to eliminate these requirements for AI systems. So again, you see somehow a solution for a problem, but the applicable law exists for AI, but some problems might arise. Now, what I've tried to show in this quite technical explanation is that we have this applicable framework of the Product Liability Directive, but a lot of problems exist when it comes to AI, and more specifically for self-driving vehicles. It is therefore no surprise that the European Commission issued several recommendations, several reports to assess the application of the Product Liability Directive. And for example, in November 2019, a very important report was issued where it said, for example, that the liability regimes in member states ensures at least basic protection for victims, but it might be possible that the changes might be necessary to ensure that the victims get properly compensated for the damage they occur. So I reckon that you may want to read this report. I will not discuss this in depth because I'm almost speaking an hour, but just if you don't find it, I can send it to you. It contains actually some key findings, some key summaries, some key important elements when it comes to the liability of artificial intelligence and other emerging digital technologies in the European Union, with a specific focus on the Product Liability Directive. Main point is, of course, it addresses a lot of elements, a lot of interesting elements, but the fundamental questions remain, namely whether software is a product and when is it considered defective. And again, when you look at the white paper, which I already mentioned, and the report that came along with this white paper, so yet another report, again, a lot of issues were tackled, but the main findings, for example, on the question of Product Liability Directive, or the concept of defectness, the concept of AI as a product, it's not resolved yet. So a lot of things will happen now in the coming months, and I really hope that we will get some insight and that the European Commission will be clear on this matter the coming months, because these are really important issues. Now, so I've shown that the first element was that AI law is not necessary, that the applicable AI is regulated by applicable legislation, but that it can be problematic and that we might need some solutions where necessary. I reckon that should be taken a step-by-step approach and not from a radical perspective. We have to really think about the changes that we want to bring, especially with such a fast evolving aspect such as artificial intelligence. Now, a fourth claim of the slide, the basic slides, which I already mentioned, is that I believe that a multi-stakeholder approach is necessary. We all have a proper background, but I'm a legal scholar, but it might be very interesting to work together with people with another background, with people with an ethical background, with people with the scientific, computer sciences, to really tackle these issues of AI and to properly regulate it, because I only think that regulating artificial intelligence can only be done by involving all relevant parties. And this is actually what we did in Flanders, in part of Belgium, with the establishment of the Knowledge Center on Data and Society. We actually consist of 3 different research centers, existing research centers. We collected our forces, we gathered the forces, so to say, into a knowledge center, and we have the Smith from the communication sciences from the VUB from Brussels, we have MICT from Ghent, and we have Center for IT and IP Law, CITIP, from the KU Leuven, where I work. And what we do is we try to enable stakeholders, for example, companies, policymakers, citizens, and regulators, to achieve the greatest social and economic benefits of AI. We provide practical information on AI. For example, now we're working on a guide of AI and GDPR, but we also try to develop a proper legal and ethical framework. We issue policy recommendation, we provide vision papers, so we really try to influence the debate on AI on a wider level for the public, but we also try to give stakeholders, companies, information on how do we deal with AI. And for example, we developed ethical tools to make sure that developers of AI can use these tools to make sure that their AI is trustworthy, as has been mentioned in the beginning of this presentation. Now, we have several deliverables in 2020. I already said that we're working on a guide on AI and GDPR. We will also do that. We are also working on the translation of these ethical guidelines into the legal framework. We will have a focus on liability law coming very soon. We will provide feedback on the white paper issued by the European Commission. So we work with many researchers with a different background on these issues. We published also, we did a survey on the COVID-19. How willing are we to give up privacy? How willing are we to give up data protection rights to make sure that public health benefits from it? So with these apps that have been developed, we did a survey on it, and if you want, we can discuss this more thoroughly whenever necessary. What I would say and what I would suggest is that that cross-border cooperation becomes necessary more than before. And my 2 weeks, even during my 2 weeks in the Brisbane Law School, at the TC Barn Law School, well, I met a lot of people, and many of you were also working on autonomous systems, on legal aspects of autonomous systems, and it seemed very interesting, and it will only become more important that we will collaborate. So what I would do, if you would like to collaborate, future collaborations, I would be more than willing to discuss this, and really I hope that I can come back to Brisbane one day to finish my ongoing research. Now, to sum up the concluding part, well, I've shown that AI raises many legal and ethical issues. A lot of things are going on at different levels. For example, in the EU, we have this white paper. I stress the importance of certification and conformity. And I really elaborate on the question whether we need a new framework for AI or not. And I refer to the slide with my basic 4 points. And I say, no, there is no AI law necessary, because AI is sufficiently covered by existing legislation that might, however, need some modification where necessary. And I think this approach should be taken as well, because we should embrace the benefits of AI while reducing the risks. And we should adapt the legal framework accordingly. So we should adapt the framework to make sure that we fully enjoy the benefits while we reduce the risks. Minimal steps might be sufficient, and we should not take radical steps when it comes to changing the law, when we would do this necessary modification. A well-considered, a multidisciplinary approach where minimal steps, a well-considered step, might be necessary. I took the example of the Product Liability Directive, but many examples are there to come. So I would like to thank you for your attention, and I really hope that we will see each other soon again, and feel free to contact me. I'm not used to talk to a computer, so if it's too fast, or I said too much, or I spoke too fast, or I was unclear, please forgive me, but it's very hectic times for me as well. In any case, I would like to thank you, all of you, for listening, for viewing this presentation, and also for having me, for hosting me 2 weeks in Brisbane. And I really hope that to come back one day and finish my research day. So thank you very much, and keep safe and healthy.